Hmm. Um, Good afternoon, everybody. This is a meeting of the House Criminal Law Subcommittee. We have four bills on our agenda for the day. And I want to start with the bill regarding privacy of judicial data. Um, Excuse me, that one is
You want to listen? Yeah.
House Bill, excuse me,
249,
664.
664. I don't see
Yep.
that.
House Bill 6.
Okay, I got it. Yeah, I got
This
it.
is
Yeah.
the Judge Wilkinson Act. So where we left this was after talking through the bill, um, we are what we'll discuss before us today is adopting the Senate amendments in case unless there's any objection to this approach. And again, the Senate amendments were to take the task force that's created in this bill and to add a representative from the State Bar Association, the public defenders, the state's attorneys, and the Orphans Court. So I didn't hear any objection to that approach. So we went ahead and are having that amendment drafted. And the other was a Senate amendment to strike the term person on page 7 of the bill and replace it with an individual. And we are made to understand that individual is humans and more restrictive than persons, which would include individuals and entities. So that was the real sort of policy strategy question. The judges had indicated they preferred the original language in the bill with a person versus the Senate changes to an individual. But I suppose we are left with the question about whether we would like to make the bills different over
Mr. Chair,
that
sorry,
issue.
go ahead. My vote is I understand their perspective, but I like to avoid conference committees because if it goes to conference committee, there's a good chance bills die and the bill already didn't pass last year.
Anyone else?
Mr. Chair, I'm fine with the change. I do not think the Senate is correct. I think that individual also includes corporations, but I'm actually checking that right now, but I don't think it matters.
I can chime in here. Delegate Cardin, an individual is a human being, and then person is actually person is defined in the general provisions. I can give you that so you can see that. So in general provisions 1-114, person is much broader, and as Chair Moon said, includes entities, trusts, corporations, LLCs, whereas individual is a human.
Okay. In that case, it's fine.
Well, can we just gut check this one?
But I don't care. I'm fine with it.
Can we gut check this one more time with our friends from the judiciary here, whether they would like us to act on their impulse that they prefer the original language and send the bill back over to the Senate with that change? Or shall we just conform to what the Senate has done?
I appreciate the request. Our preference at this point, given where it is to adopt the Senate's changes and avoid the conference.
Okay. So, do I have a motion?
So move.
On the amendment. All right, so all in favor of adopting the Senate amendment, say aye or raise your hand.
Aye.
Any opposed?
Not opposed, but Mr. Chairman, just got a question for you.
Yes.
On that amendment, you said is the individual members of the State Bar Association and the Orphans Court?
So it adds to the task force, the State Bar Association, the public defender, the state's attorney, and the orphans court.
Okay, so it's adding to the task force and not specifically saying that those persons would be a part of the shielding of information.
Correct.
That makes
Correct.
sense. Okay, all right, thank you.
Okay, so now we're on the bill as amended. Does anyone have any remaining questions before we set this thing upon the world? No questions. I'll just
Move
say
favorable,
I
Mr. Chair.
what's that? Move favorable. Okay.
Second.
All right.
Mr. Chair, I'm very happy that we're setting up a precedent to make sure that that we take our judiciary seriously and know that they can be put in harm's way. And this is a tool. It's not a definitive, but it's a tool to help make sure that we keep them safe. And
Absolutely.
I'm thrilled to second that motion.
But I think I accidentally cut you off, Mr. Chair. I'm sorry.
No, you're good. Besides Delegate Cardin had some nice remarks to make. All right, so we have a motion for a favorable on House Bill 664 as amended. All those in favor of that recommendation, raise your hand or say aye.
Aye.
Would anyone like to be recorded in the negative? Okay, so I guess we're on to the committee with that one. Thank you, judges, for your participation and attention.
Thank you all very much. Have a good afternoon.
Take care. See ya.
All right, we are gonna skip over to House Bill 249, which was the bill dealing with DNA collection procedures. So we have 3 amendments to the bill. One was by request by the police to clarify that if they fail to collect a sample, they have, but it made that attempt that they have discharged their duties as instructed. And then we have 2 small amendments to the bill text on page 6 on line 1 to add the word sub to subsection, and then on line 17 to change an or to an and. And these were items that were flagged in last week's work session. Does anyone have any additional discussion, questions about these changes before we? Yes, Brenda. I see a hand up.
Yeah, I had to click OK before I could click unmute. So sorry. I'm Brenda Jones with FAIR, for those who don't know. I'm assuming that I'm here as a stakeholder and thought perhaps our suggestions of amendment were also being included regarding the DNA.
We took a look at it. And sorry, I have to refresh my on what
I have it if you want me to.
Yes, that's right. You had requested a language that there didn't need to be a sample collected twice.
That was one aspect, yeah. Unless DNA has previously been sampled and the results are obtainable by the supervising authority, that was one change as a possibility. And then just the word of initial registration, because we were concerned the language wasn't quite clear. And although we're sure the intent was that they would only have to get their DNA sampled once, people have to register sometimes weekly, and we kind of figured we didn't want to have it in there to make it sound like they have to get their DNA sampled every time they go in.
Yeah,
just
and
change
so
that
our
there.
discussion of this last week was the response we heard from police was that this wasn't seemingly an issue that was going to happen, but that in the scenario, you didn't want to create a scenario where you undercollected, but with an expungement process in there, but that they didn't feel this was likely to be an issue. And so unless I hear from members otherwise, I believe the subcommittee was disinclined to take up the amendment request, but I'll open it for discussion.
Sure, that's, yeah, I wasn't here at the last one, so just checking in. Thank you.
No, not a problem. Do any other members have anything to add to that discussion?
Are there any, no, I'm sorry, I was gonna suggest moving the amendments. I don't know if you, so we can deal with the amendments and then talk about the bill generally.
Yeah, sure. Okay, so that's a motion to move the 3 amendments, one from MSP regarding discharge of their duties when they fail to collect a sample, and then the 2 single word changes that we discussed last week. Do we have a second on that?
I'll second it.
All right. So we have a motion, a second on the amendments, 3 of them. All in favor of the, all right, hold on. We've got a hand from MSP. Would you like to comment on that language before we vote it on?
Yes, sir. Just wanted to make sure that the amendments that were prepared by committee staff, amendments 583, 424/1, because there's 2 provisions in that amendment. One is the discharge of duties, and the other is the language regarding the refusal to submit requires that it's referred to the state attorney's office for prosecution.
And maybe can we just confirm with council that we are in fact talking about that same language in hand?
Yes.
Yes.
Great.
Thank you, sir.
Okay. Now I will call the vote. So all in favor of adopting those amendments, raise your hand or say aye.
Aye.
Would anyone like to be recorded against? Okay, now the bill as amended is before us.
Move favorable.
Second.
All right, all those in favor of the bill as amended, raise your hand or say aye.
Aye.
Would anyone like to be recorded in opposition? Okay. Thank you very much. We are going to move on to Delegate Rosenberg's bill. This is House Bill 128, and it involves taking the crime or creating a crime out of interfering with legislative proceedings and witnesses and testimony in legislative proceedings. And this bill was seemingly cloned off of similar law regarding messing with a judicial proceeding. The bill proposes a misdemeanor max 10 years on this offense. And Delegate Rosenberg, just we have this bill and one more bill that we hope to just do a quick discussion on and get questions, but probably not take action until next week. But do you want to quickly give us a 1-minute refresher on what this bill does and why we should do it?
Sure. It is cloned. Just to be clear, it is, you said it was seemingly cloned, but no, it is cloned on the language in the code, criminal code, regarding interfering with a judicial proceeding. So we have taken that language based on, in response to an incident that occurred several years ago in HGO. Delegate made me aware of the problem, and this is the legislation that would address that. People should not be
Would you
intimidated.
mind actually for our I don't have the history of of the incident that gave rise to this bill.
Well, people testified on a pharmacy bill, and then very soon thereafter, heard from their provider in a not so subtle way that regarding their testimony, and
Right.
they were not intimidated. I mean, they weren't deterred, but this kind of conduct should not be sanctioned or go with that, be indifferent. Our response should not be indifferent. And Delegate Kipke is the colleague who told me about this, and is this at the present time the sole co-sponsor of the bill.
And I see a question from Delegate Cardin, but just one quick one. Is the penalty structure the same as in the judicial interference?
I'm sure that it is.
Okay. Delegate Cardin?
Thank you, Mr. Chair. I love the bill. I just want to make sure. So if somebody testifies and then is somehow harassed or intimidated afterwards, this doesn't apply to that, right? Is that what you were just talking about?
Well, I'd have to look at this. I would hope that it would. Now, it could be harassment before or after.
But
I
thought
be.
the
I don't
person
know.
may not harm or threaten another with the intent to influence the witness in terms of their testimony. Person may not intentionally harm another, threaten another, or damage or destroy property with the intent of retaliating against a witness. So you can't intimidate them to make them not testify, and you can't threaten them after they testify. But the definition, I thought the prohibition was to interfere with a legislative body, being a committee or a task force or a work group established by statute. And while they're in a legislative proceeding, which would be, regardless of the meeting is happening, it's whether if a quorum is present or if the General Assembly is in session. So I'm trying to figure out, so if somebody comes in and disrupts the hearing, this doesn't apply to that. But if somebody intimidates a witness who's trying to testify at a hearing, it does implicate on that. Is that correct?
Well, it speaks to actions taken with regard to a specific witness.
Yeah.
And I would certainly, if the committee feels that it needs to be made clear that that is before, during, or after the hearing, to make that clear. And if amendment is needed to make it broader than the judicial proceeding, the existing language, I would certainly support that.
Okay.
Because it furthers the intent of the bill.
And this, I just want to make sure we understand that we're dealing with not just legislative proceedings in terms of the General Assembly, but if there's a task force, if there's a work group that's set up by legislation, this, and it's out, and the work group is meeting and out in front of City Hall.
Right.
And somebody comes out and starts yelling at them because they're unhappy. Could this implicate that person who screams and disrupts that work group?
I would think so.
Okay. And is it only for those created by the General Assembly, or could it be a legislative proceeding in a local jurisdiction? or municipality? Anybody know?
You kind of broke up, Delegate Cardin. I missed the last part of you said.
To local government.
Yeah, Delegate Cardin, I think you might have froze on us. All right, I'm going to,
Okay.
let's move.
It's saying in there, I'm sorry, in the fiscal summary that is, this bill is not expected to, materially affect local government operations or finances. So I don't know if it would intentionally affect local government.
Well, if I may,
Yeah.
the state effect in the fiscal note is the same. So if the bill as written would not affect the state, if amended to include locals, I would assume that it would not be expected to materially affect local government costs as well.
Delegate Sample Hughes.
Thank you, Mr. Chair. So Delegate Rosenberg, I'm familiar with the challenges that we've had over the years in HGO with the PBMs causing challenges for the pharmacists. The example that was used in their support letter, Epic Pharmacy, speaks about the threats of no longer allowing the pharmacies to be a part of the network, and that they then incurred spending a lot of money for audits to occur. So is our goal to take care of the intimidation and the threats after person may have been a part of the legislative testifying process, or or this legislation supposed to speak to what the prohibited acts have outlined in the legislation, which doesn't tie to Epic Pharmacy's letter? So I just wanted to make sure we're covering what you're trying to address.
Well, I think this consideration today by the discussion has made me aware that the bill should address any intimidation as defined in the bill that takes place before, during, or after the whole ball of wax.
Okay. Yeah, I thought that's kind of where you were going with the whole ball of wax. But I just wanted to recognize that the prohibited acts outlined in the bill does not really speak to what the witness is trying to get coverage for, if that makes sense.
No, I'm for a reasonably broader language.
Okay. Thank you, Mr. Chair.
Delegate Boucher.
Thank you, Chairman. I'm just wondering, excuse my ignorance, about the administrative implementation of this, because I'm concerned about public awareness. Would this be put on the website and a notice of a link when people go in for the sign up as to be a witness? Will they receive public awareness? Because I think that's critical that the public knows about this law that preempt this from happening. How does that unfold?
Well, the old saying is everyone is presumed to know the law. So one would expect that people would, and it would be then up to this legislative body could, I'm not going to speak to whether it should be required in the bill, to put a notice. Well, look, there's a notice regarding carrying of a gun. There could, I'm not taking a position, just hypothetical, there could be a notice at the entrances to the State House, to office buildings to that effect. But I would tend to go with the sense that everyone is presumed to know the law. You know, that this would not be some obscure criminal law. It's saying don't intimidate people.
Right. Thank you.
If you don't mind, I would just add to that by saying that if this is something that does move forward, I think there should be some mechanism with legislative services to draft maybe a shorter version for notification, because you could get individuals that feel that their freedom of speech, is being, they're executing their freedom of speech, and then we have this law on top of that that restricts it. So I think how it plays out is just as important as how we notify individuals, especially of their rights.
I defer to the committee.
Yes, sir.
Delegate Roberson.
I'll just raise that. I mean, you would hope that we shouldn't have to provide notice that people shouldn't obstruct justice and get in the way of, threatening individuals as they testify, before anybody. So I understand what we're saying about letting them know their rights, but it says a person may not, what's prohibited is a person may not harm another, threaten to harm another, or damage or destroy property, which should be understood regardless whether you may give notification or not. We should all understand that you should not be threatening anyone nor harming someone, regardless if it's to testify before a committee or whether they're just going to talk to another individual. So I kind of push back on the fact that we need to provide this notification to individuals. And I feel as though as it's written, we could move forward with it. But, I follow the will of the body. Thank you, Delegate Moon.
Delegate Rosenberg, I have just one quick question here. When it contemplates a person may not intentionally harm another for retaliation for giving testimony in legislative proceeding, is the harm you're contemplating both a business harm and a criminal harm? And so like the pharmacy benefit manager, that example that's given, right? Like people with a business relationship end up on different sides of legislation, and after the hearing, one says to the other, USOB, I can't believe you went against us on this. I'll never work with you again, or things of that nature. I'm not sure if that's intended to be included here.
Gee, if it's a co-equal, my thought off the top of my head is, if it's a co-equal relationship, then perhaps that shouldn't be included, but I'm not sure even there. But clearly, if it's, not a co-equal relationship, the one who has more power should not be able to harm a witness and cause damage to that individual physically, that person's property, or that person's business.
I mean, it's interesting. I'm sorry. I don't want to go down law school hypothetical lane since we're trying to wrap quickly. But the next one I'm thinking of is an employer and employee testifying on opposite sides of a bill and saying, "Oh, that's how you feel. You're fired," or or something like that.
Well, there's testimony and there's testimony.
Yeah,
and that would be the bad kind.
Delegate Embry.
Hi, thank you. And I'm sorry, I'm waiting for my bill to be heard in another subcommittee. But I did express this at the hearing. I think we need to really limit what we mean by harm, because people testify in all kinds of ways. They can say very hateful things, very problematic things. This is not fact testimony. This is, we know in judiciary all the kinds of things people say. And I just wouldn't want this to encompass, this encompasses right now all relationships, not just employer-employee, family relationships. I think we just need to be a little more specific about harm so that we're not preventing people from appropriately reacting to testimony that might be problematic, genuinely problematic in a given situation.
Delegate Grammer.
Yeah, Delegate Embry kind of nailed my point. I was going to ask, what is the definition of harm? I'm peeking around. I don't see it. I would agree with her sentiments, but if someone could define harm or tell me where it's defined, that would help me.
Well, the one view, the conservative view, which is fine with me here, would be it's the dictionary definition. Absent a definition in the bill, a court would look to a dictionary definition of harm. That would be the plain meaning.
Yeah. So this is interesting if this language is in fact directly cloned from the judicial section. You know, maybe it's worth taking a look at that. Okay. Well, this is a good kick to this conversation. Like I said, we'll continue this one next week. So thank you, Delegate
Thank you.
Rosenberg. Let's very quickly just take a look at the arson bill that Delegate Attar brought. And again, we're just going to try and do this real quick, just because we won't take action today, but just so that folks can be reminded of it. It looks really simple and short. So Delegate Attar, can you just give us the 30-second refresher on why we need this bill?
Thank you, Mr. Chair. Absolutely. So the bill itself, if someone commits an arson and a firefighter is injured or with the amendment or dies as a result of that arson, this would create either 10 years for the injury or 20 years for the death. This is necessary because it's circumstances, some of which can't be discussed because it's pending litigation, where firefighters were injured or several have died, and we did not have this law in place. I see there are actually many experts on here if we have any questions, but thank you.
And sorry, it's what is the penalty for arson without this added? Like if it didn't cause a injury.
If it didn't, okay, so let me second. Lauren, do you have it in front of you? I'm sorry, I'm trying to pull up all my notes and I should have had it already. Is it okay if Mr. Campbell answers?
Sure.
And I just need to pull out my right binder.
So the current penalty for arson first degree is 30 years.
30-year felony. Okay. And then this would be, you would add 10 if it, maybe add 10 if it actually caused an injury.
Yes, for a first degree, it's 30. And then if it's a second degree arson, it would be 20 years. Yes.
It's very straightforward.
Can I ask a question?
Yes.
Thank you. So, is this to try and give people who, when there's a death of a serviceman in fighting the fire, to get them 40 years or 50 years if it's arson first degree, 30 years if it's arson second degree? Is that the intent, or is the intent that if it's a fire that can't be considered arson 1 or arson 2, but it's still arson, to get somebody in jail for 10 or 20 years? What's the intent of the bill?
Well, I'll just jump in and say the intent is to ensure if firefighters are killed or badly injured as a result of an arson, there are appropriate consequences for the arsonist. So let's say it's arson second degree that they have 20 years. I don't think if 3 firefighters are killed, 20 years is appropriate, especially because we know most people don't get 20 years. It'll be 20 suspend all, but something, this would give additional.
Okay, well, we can get into the debate about whether what you're getting is what you're actually getting. That's true with every single bill that comes into judiciary. I'm just trying to figure out what we're, in terms of the sentence that you're getting. Right.
May I take a stab at this in terms of response? Sure. The issue here is an intent issue. And so when we're talking about arson, when we're talking about felony murder, when we're talking about manslaughter, when we're talking about malicious burning, we are talking about different intent proof requirements that we as prosecutors have. And so one of the examples that was used during the committee hearing was an individual who set fire to curtains, and the curtains then caused an entire apartment building to go up in flames and thereby seriously injured in a life-threatening manner Lieutenant Novak. That was part of the testimony that was heard by this body. The issue is that when it comes to charging, and I've been doing this for almost 20 years as a prosecutor, and I certainly don't want to step on other people's toes if they've also had prosecution experience, but the issue comes down to charging. And so in in that fact pattern with the curtains, the intent of that individual was to set fire to those curtains in order to, quote, smoke her boyfriend out. That was the testimony we heard, and I'm familiar with that case. It was ASA Varda's case.
Right. It was not to kill the firefighter.
Correct. And so that was the issue, is that we really had also a malicious burning. And so the charges that were attendant to that, in terms of the intent that we could prove, was a malicious burning, as well as we attempted reckless endangerment. And then we ended up getting mired in whether or not this individual was attempting to recklessly endanger the firefighters who ended up being injured. So House Bill 321 cleans that up in terms of permitting, so any of the burning statutes, which I think is probably a little bit more appropriate because they're not all arsons, but any of the burning statutes, if that burning results in the injury or death of a firefighter,
then intent is not required. You're not required to have intent.
Right, we go from specific to general. And what's also important to remember is that this does not capture accidental burnings, does not capture it.
Okay, from a civil side though, Mr. Chair, I'm sorry, one more question. From a civil side, they still have the ability to try and get compensation for the firefighters because they don't need that intent, that specific intent. Is that correct or is not correct?
I believe that's correct.
Okay, so the question is whether, because they only had the intent to try and destroy property, but in the end, somebody wound up getting seriously injured. Should the person go to jail for 20 years, even though his intent was never to cause anybody any injury? That's the essence of the bill. I just want to make sure.
Is that a rhetorical question?
Huh?
It is a rhetorical question.
We don't need
to get into that.
I just want to.
If someone sets fire to a building for insurance fraud, and someone gets injured, should they do time for that?
Right. Or if somebody sets fire to a trash can outside a house and it winds up spreading, and their goal was to send a message by burning the divorce papers, and it wound up spreading and causing injury to somebody inside the house, should they do time?
I mean, Mr. Chair,
I thought that Lauren's explanation was very clear.
Yeah.
As to the reason for the bill in that regard. I'm sorry, we only have a couple more minutes left, so let's just quickly get a couple more questions out from Delegate Robertson and then Bartlett. And if you could make these very quick questions with very quick answers, we'll punt this back to next week's agenda. But just wanted to give everyone a taste of the convo here. Go ahead.
Yeah, mine is very quick. I just want to know, I see the Baltimore fire officers were submitting an amendment. Did we have that? Had they worked with us or with Delegate Asara?
I believe that amendment was for the death, because it doesn't include currently if there's a death. So if there's a death, then it's 20 years.
Okay. Delegate Bartlett.
Thank you, Mr. Chair. I wanted to ask the question that I didn't get to ask in testimony, and that is, when someone calls in a fake call, I want that to be included or referenced in this bill, and I wanted to suggest that as a friendly amendment, because while there is no fire, someone could be injured on their way to the fire, and they would not have been injured but for that fake call. So I just wanted, I know we call it swatting, and I don't know if it's already in the swatting bill, but I think it should be referenced, or somehow, I think it should be referenced here in this bill. And I wanted to put that in as a friendly amendment.
That would absolutely be a friendly amendment to the sponsor.
Okay. All right, so we have some questions to resolve for next week. There's an amendment request to add these fake calls to 911 in. There's an amendment request to add death and a higher penalty in for causing death. And then we, of course, have the larger question about, as Delegate Cardin is raising, whether to do this bill. But like I said, we'll be back with this conversation next week. So thank you all for joining us.
Thank you, Mr. Chair.